so you've proven you're injured. That's step one of standing. But the Supreme Court has two more hoops for you to jump through, and they're designed to make you fail. Step two, causation. You have to prove the defendant actually caused your injury. Sounds fair, right? But here's the trick. Courts demand you prove causation with near certainty, even when that's impossible. Take Allen v. Wright. Black parents sued the IRS for giving tax exemptions to racially discriminatory private schools. Their argument? These tax breaks help racist schools thrive, which reduces integration in public schools and stigmatizes Black children. The Supreme Court said, prove it. Prove that if we took away these tax breaks, the school would actually integrate or close. Prove that white families would then send their kids to public schools. You can't predict human behavior with that certainty. Case dismissed. Think about what that means. The IRS was literally subsidizing racial discrimination with taxpayer money, and the court said nobody could challenge it because the chain of causation was too speculative. Step 3, redressability. Even if you prove causation, you have to prove a court ruling will actually fix your problem. If third parties not in the lawsuit might mess things up, you lose. Take Luan v. Defenders of Wildlife in 1992. Environmental groups challenged a regulation about protecting endangered species in foreign countries. The court said, even if you win, we can't force foreign governments to change their projects. So why should we hear this case? Standing, denied. Here's the pattern. When the injury depends on how third parties might react to a court decision, courts throw up their hands and say, too speculative. Never mind that most legal remedies depend on how people respond to court orders. But watch what happens when courts want to hear a case. Texas sues over immigration policy, claiming it costs them money to provide services to immigrants. That's a chain involving federal enforcement, immigrant decisions, state budgetary choices, way more attenuated than the Allen plaintiffs. Standing, granted. The causation and redressability requirements aren't neutral principles. They're tools courts use to dismiss cases they don't want to decide. Civil rights cases challenging systemic racism? Too speculative. Environmental cases about pollution? Can't prove this specific defendant caused your specific harm. But when the preferred plaintiffs show up, suddenly causation gets a lot easier to prove. This is why the standing doctrine matters. It's not just procedural nonsense. It's the Supreme Court deciding which injustices get a day in court and which ones don't.